Good morning, Mr. Greenie.
Good morning, sir. This morning, first, we will hear submissions from Mr. Raymond Foster. So I'll start again. This morning, we will hear submissions from Mr. Raymond Foster, and he will address you on behalf of the families represented by Fox Law. Mr. Foster.
Good morning, Mr. Foster.
Good morning, sir. So my name is Eamon Foster. I appear with Mr. Sothey, King's Counsel, and Mr. McGowan, instructed by Fox Law to make submissions on behalf of the core participants that they represent. Sir, at the outset, I would say that we endorse the approach adopted by Council to the inquiry as per the note of the 14th of May 2025 in respect of the redactions of the names of junior civil servants prior to being disclosed to core participants, as well as the 4 categories of suspects. We've set out our position in our written submissions, and they should hopefully be with you. However, we would like to take this opportunity to make some short additional oral submissions and observations in respect of the proposed redactions of the names of junior civil servants. In particular, our concerns are about the status of core participants and the duty of candour in light of the importance of openness and transparency to ensure public confidence. A number of the core participants that Fox Law represent were involved in a campaign that had one intention, sir, to establish the truth. At the conclusion of the judicial review proceedings brought by Mr. Gallagher, Mr. Justice Horner, as he then was, determined that there were plausible arguments that there was a real prospect of preventing the Omagh bombing, and that there would be an Article 2 compliant investigation should be established, which would be necessary and would involve the scrutiny of both open and closed material. This inquiry was established to carry out that scrutiny through its inquisitorial function into what happened and what can be learned. As indicated in our submissions at paragraph 4, we submit that it should be remembered that there was an excessive secrecy applied in the past in the context of Northern Ireland, which would imply that justifications relied upon should be reviewed with the utmost care. In this context, I want to refer you to paragraph 17 of the skeleton argument submitted on behalf of the Secretary of State, in which it is stated, "This is not a situation in which it is proposed to withhold the names from the Chair or the inquiry legal team. But we respectfully submit, sir, that by inference it is proposed to withhold them from the core participants, and thereby excluding them. And we submit, introducing at this early stage a level of secrecy into process that's contrary to the core participants' expectation of overarching openness and transparency in order to have an effective investigation to ensure that there can be full and proper scrutiny." On that point, I refer you to Section 5 of the 2006 Inquiry Rules, and in particular, subsection 1 and 2. And firstly, I would highlight the word designate. In that subsection...
Could you just bear with me a second, Mr. Foster? I just want to open up my documents. So sorry, you wanted me to look at Rule 5, was that
Yes,
so?
yes, Chair.
Yes.
And subsection 1 states, "The chairman may designate a person as a core participant at any time during the course of the inquiry, provided that person consents to being so designated." We submit that by being designated, that individual is being given a status within the inquiry and part of the function within that inquisitorial function. I will bring you then to subsection 2. And in this section, I will highlight the word significant. And in subsection 2, it states, in deciding whether to designate a person as a core participant, the chairman must be in particular consider whether the person played or may have played a direct and significant role in relation to the matters in which the inquiry relates. B, the person has a significant interest in an important aspect of the matters to which the inquiry relates. Or C, the person may be subject to explicit or significant criticism during the inquiry proceedings, or in the report, or in any interim report. Therefore, we respectfully submit, in order to be a designated core participant, to obtain that status, a person, an individual, must possess a feature of significance that is important to the subject matter of this inquiry. They have a status before this inquiry. They are a participant, they are a core participant. But on the basis of paragraph 17, it has been proposed at this early stage to exclude them and dilute that status. I would highlight to the inquiry, sir, that some of the core participants that Foxlaw represent have been involved in campaigning for this public inquiry for over 20 years. This included the lengthy judicial review proceedings brought by Mr Gallagher following the decision in 2013 of the Secretary of State at that time not to hold a public inquiry. It also involved an extensive set of civil proceedings against a number of dissident Republicans. They also commissioned a report, the Bridger Report, into the circumstances surrounding the bomb. They also gave evidence to the Northern Ireland Affairs Committee. That's notwithstanding the numerous meetings that were held and arranged with various individuals over that period of time. And Mr Gallagher is currently engaged in proceedings regarding the effectiveness of the police investigation following the bomb. I believe that Counsel to Inquiry commented yesterday that it should not be assumed that the inquiry has all the wisdom. I would respectfully submit that some of that wisdom does rest with the core participants. There is a knowledge and insight and wisdom that cannot be excluded or diluted.
I perhaps infer that what you're submitting, Mr Foster, when we look back at paragraph 17 of the skeleton argument for the Secretary of State, is that the duty of candour, which was being discussed there, is not just a duty of candour to me as the chair of the inquiry and to the inquiry legal team, but a duty of candour more broadly to the inquiry and to those who participate in it.
Yes. That's correct, sir. And paragraph 17, the Secretary of State's submissions continue that the legal team for the inquiry will be well equipped to assess the relevance and significance of the documents as they undertake their review. We would submit, sir, that that goes to undermining the knowledge and insight that is available within the core participants, and also the status that has been afforded through their appointment or designation as core participants. In fact, sir, why else would they be designated? They possess something that is significant to the inquiry. And I think it has also to be reflected that designation wouldn't necessarily be automatic. And it's not the case that everybody that applied for designation were accepted. And I think there's an important aspect here, sir, in becoming a core participant. They've also given an undertaking to you, sir, as chairperson, in respect of confidentiality. And I would like to take a minute and refer you to that document. In that document, it states that the individual undertakes to keep all such documentation safe and not to leave it unattended other than at a secure location. Keep all such documentation confidential, and only use such documentation for the purposes of the inquiry into the Omagh bombing and any directly related legal proceedings. And further, it states that only any disclosure or discussion should take place with people who have given identical undertakings. And it's the responsibility of that person to ensure that any person has that undertaken before discussing or disclosing any document or information. And that raises a question, sir. How is that undertaken viewed by the Secretary of State? What weight has been placed on it? There have now been 6 tranches of disclosure, and no evidence has been adduced by the Secretary of State, or even a suggestion that that undertaking has been breached. Again, we would submit that the proposed redaction goes to undermining the significance of that undertaking and the associated integrity with an undertaking of confidentiality. I referred earlier, sir, to the core participants' expectation of openness and transparency, which introduces the duty of candour. At paragraph 2 of the submissions on behalf of the Secretary of State, with reference to the IAB case, it is stated that it is important to recognise that those observations relate to the very particular duty of candour that the government owes in judicial review proceedings. We would respectfully submit, sir, that an observation arises out of that regarding what is meant by a very particular duty of candour. Does that mean that there's a hierarchy of a duty of candour applicable to a judicial review or to an inquiry? We would say that there's no hierarchy. We respectfully submit that a duty of candour is just that. It's a duty of candour, an obligation and responsibility to be open and honest. When it comes to the relevance of documents and the significance of documents, that's a matter for the inquiry. Not to be predetermined, not to be dealt with by blanket anonymity. And we respectfully submit, while an inquiry may have a wider role in judicial review proceedings, it does not lessen the duty of candour. It's still present, and we would actually submit that it reinforces the need to exercise that duty, given that the statutory power to establish an inquiry is based on public concern. As indicated in the note of counsel to the inquiry, you, sir, have an expectation of complete candour from all core participants. And Mr. Graney has emphasised the word complete. And further, reference is made to the expectation that the state core participants understand and exhibit the Hillsborough Charter and the Hillsborough Law. We submit that that expectation of complete candour from all core participants should be the very particular duty of candour attached to this inquiry. We submit that the duty of candour goes to the heart of the process of ensuring an effective investigation because it impacts upon public confidence. That the scrutiny referred to by Mr. Justice Horner is steeped in openness and transparency. To repeat the words above, there's a necessity for complete candour from all core participants. They, by doing so, will assist collaboratively in the process of establishing the truth. And we say that the core participants, represented by Fox Law, are here to assist and work collaboratively to establish that truth. In summary, sir, we say that the core participants have been designated a status within this inquiry to work collaboratively within that inquisitorial function to establish the truth. We say that there is no hierarchy of duty of candour. It is what it is. Unless there's anything else further, sir.
Was there anything else you wanted to say about the PSNI application?
No, we endorse the note of the Council to the inquiry in respect of that.
Thank you. Well, Mr. Greenie.
So thank you. We will now make some short, I hope short, closing remarks on behalf of the inquiry legal team. Yesterday in our submissions, we made plain that in March of this year, 80 documents could not be disclosed to core participants because of the outstanding issues of redaction that we have been considering over the course of the last 2 days. That figure now stands at approximately 700 documents, which amounts to about 8,000 pages. Accordingly, as we observed yesterday, the need to resolve the issues of redaction has, as an objective fact, placed a brake on the work of disclosure of the inquiry. However, we must be clear that in referring to that brake, we were not to be taken to be suggesting that either HMG or PSNI has been deliberately impeding the work of your inquiry. We, the inquiry legal team, are sure that they have been doing no such thing. HMG considered that there was an important issue to resolve, and although, as we will explain, we do not consider their argument sustainable, we accept that it was advanced in good faith. And, as we said yesterday, PSNI has raised issues that are important ones for your consideration. And so we consider that all of that should be understood. Against that background, we have final submissions to make on the junior officials issue and on the PSNI issue, rather more about the former than the latter. But before we develop those submissions, it's important that we should repeat that what we are concerned with in this hearing is only whether material should be disclosed unredacted to core participants, not whether it should be disclosed into the public domain. So first, the junior officials issue. The effect of the decisions of the High Court and the Court of Appeal of England and Wales in IAB are clear, indeed beyond clear. As the Court of Appeal put it in the final paragraph of its ruling, that's paragraph 36, and I quote, "Defendants in judicial review proceedings do not fulfil their duty of candour save for good and specific reasons if they disclose documents with redactions of the names of civil servants. I am struck," said Lord Justice Bean, "by the robustness with which both Swift-J, a judge of almost unparalleled experience of public law litigation, both as Treasury Counsel and later as a judge of the Administrative Court, and Fordham J, another judge with an encyclopedic knowledge of judicial review, have rejected the arguments for routine redaction. I agree with them." In fact, the judge said, "I entirely agree with them." The practice is inimical to open government and unsupported by authority. If Parliament takes the view that members of the civil service have a general right to anonymity in judicial review litigation, then it should enact a primary statute to that effect. End quotes. And so, as you will know, the reference to Mr. Justice Fordham in that final paragraph is a reference to his decision in the case of Snedden, which is to the materially identical effect as the decision of Mr. Justice Swift in IAB at first instance. So, the approach of redacting the names of junior officials from documents in judicial review proceedings was strongly deprecated in IAB. And yet, that is precisely the approach that HMG proposes to adopt in this inquiry. That, we suggest, will require HMG to distinguish IAB and to explain why the reasoning that was so roundly rejected in that case is in fact, and to the contrary, sound in the context of your public inquiry. The position of the inquiry legal team, having heard the argument over the course of most of yesterday and a small part of this morning, is that HMG has failed to establish any meaningful or sufficiently meaningful distinction between the reasoning in IAB and the reasoning in this case. To return to the reasons that have been advanced by the Secretary of State, and dealing first of all with relevance, we have 3 points. One, as we pointed out yesterday, in IAB at first instance, Mr. Justice Swift made clear the practical difficulties that the redaction of the names of junior officials from documents makes. Without going again through the full passage that we cited yesterday, the judge explained, and we quote a small part, redaction leads to significant practical difficulties. And he later continued, at the least, redacting names makes the decision-making process and the significance of each document disclosed more difficult to understand. In some instances, it may obscure the significance of a document almost completely. And so in circumstances in which the judge was anticipating that there would be circumstances in which the significance of a document might be almost completely obscured, it is hardly surprising that he described the practical difficulties created by the proposed approach of HMG as significant. HMG suggests, as we have understood it, that the reasoning of Mr. Justice Swift in IAB, and indeed the reasoning of the Court of Appeal, does not apply to a public inquiry because Mr. Justice Swift was expressing a view in the context of judicial review in which only significant documents, as Ms. Fee put it, will be disclosed, giving rise to a, it was said, particular duty of candour, whereas the inquiry will be disclosing, as it was put yesterday, relatively innocuous emails and documents that, while relevant, are not significant. So as we understood it, the distinction relied upon was said to arise from the fact that, on the one hand, in judicial review proceedings, only significant documents are disclosed, but in these proceedings, documents that may be, again we quote, relatively innocuous emails may be disclosed. That analysis does not seem to us to be sound. First, if what was being proposed by HMG was that the names of junior officials should be redacted only from relatively innocuous emails, it might be possible to follow the logic of the argument. But that is not what is being suggested. What is being suggested is that the names of all junior officials should be redacted from all documents. We presume that HMG accepts that at least some of the documents we disclose to core participants will be significant, not relatively innocuous. So it follows that redactions will inevitably be made on the HMG approach to significant documents. So even on the approach of HMG, the reasoning of Mr. Justice Swift will apply precisely, and the practical difficulties he describes will blight this process. Second, even if the argument of HMG were to be that the names of junior officials should be redacted only from relatively innocuous emails and similar documents, which of course is not their position, it would not work. And that is because any such argument would assume that the probative value of a document can be determined with certainty at this stage. In our view, that is plainly wrong as a general proposition. So, as you know, the inquiry legal team receives from material suppliers documents that the material provider considers potentially relevant. The inquiry legal team assesses those documents and then discloses to core participants those documents from the material disclosed to it that it assesses to be relevant to your terms of reference. So relevant documents are disclosed to core participants. What cannot be assessed with confidence at that stage, at least not necessarily, is quite how much probative value any particular document will ultimately have. A document that appears to have a high degree of relevance, or to be significant, as HMG puts it, may turn out not to be so because another document or witness explains its true meaning and it turns out to be unimportant. Conversely, a document that appears of marginal relevance may turn out to be significant when put together with other documents or when explained by a witness. And we dare say that every lawyer in this room will have had such experiences. Something that looks important, that when the true picture is revealed is not. Something that looks unimportant, which when the true picture is revealed is important. So that is connected with the second point on relevance, which is this. The bold proposition that the names of all junior officials are irrelevant is one that we simply cannot accept as having a sensible foundation. The true significance of a document cannot, as we've just submitted, necessarily be determined at this early stage. And that means that the relevance of any particular document and the importance of any person referred to within it cannot be determined at this stage. A relatively innocuous email may turn out to be significant, as we have submitted, while a person carbon copied, CC'd into an email may simply have been copied as a courtesy and hardly have noticed that happened. Alternatively, that person may have been copied in because they were an important decision maker, or because, as is revealed when a statement is taken from them, they were a witness to a connected meeting of importance. It is simply impossible to say at this stage whether a particular name is or is not relevant within a relevant document. And that means that the only safe, fair and principled approach is to proceed on the basis that the name of someone contained within a relevant document is relevant until it becomes plain that it is not. As Mr. Mackey put it yesterday, HMG is approaching the issue from the wrong end of the telescope. We agree. The third point arises from HMG's attempt to distinguish IAB on the basis that the material will come to the inquiry legal team unredacted, unlike in IAB, in which the court received redacted documents. We acknowledge that is a difference, but we suggest it is not one with real meaning in the context of this argument. The argument of HMG appears to be that we, the inquiry legal team, will be able to look at the unredacted version of a document, say to ourselves that a particular name of a particular junior official is relevant, and so lift that particular redaction when the document goes to the core participant. Well, we agree that in some cases that may be so, but in all cases, is it to be suggested that we will recognise the relevance of the names of all junior officials in all documents? As we put it yesterday, and as Mr. Foster referred to today, that assumes that the inquiry legal team has a monopoly of wisdom. And we are modest enough to acknowledge that we do not. Our highly informed core participants have, as Mr. Foster has just put it, a knowledge, an insight, and wisdom that cannot be excluded or diluted. We agree they have a vital role to perform in identifying whether any particular junior official has important evidence to give or may do. If the call participants receive redacted documents or documents with the names of junior officials redacted, they will not be able to perform that role, and our process will be the poorer. And even if there has been candour with the inquiry, there will not have been full candour with the core participants. So, sir, for all of those reasons, and for the reasons that we gave yesterday, which we submit hold good, we suggest that you should reject the contention that the names of all junior officials are irrelevant. As for privacy, the proposition that junior officials have a reasonable expectation of privacy and confidentiality as a class is one that we consider you should also reject. One, HMG has wholly failed to establish any proper evidential foundation for that proposition, despite having had every opportunity to do so. Two, as we explained yesterday, Mr. Justice Swift dismissed and roundly dismissed a materially identical argument in IAB, and his words do deserve repetition. I do not consider any such general expectation, even assuming it exists in practice, could be reasonable. No such expectation would attach to any person as a matter of general employment law. Moreover, when at work, civil servants are not involved in anything that can be described as a private activity. They are exercising public functions as part of the public service of the country. It is also material that while the Secretaries of State's submission refers to the class of junior civil servants, this label was applied only to distinguish them from the civil servants working in grades comprising what the government refers to as the senior civil service. Therefore, the distinction between junior and senior civil servants is akin to the distinction between junior and leading counsel, and is not necessarily any indication of age or experience. The class of junior civil servants includes civil servants with significant responsibilities. So in that passage, Mr. Justice Swift was plainly not expressing a principle that applied only in judicial review proceedings. Instead, he was expressing a principle of general application. We submit that the judge's reasoning is sound and applies equally to the argument that has been presented by HMG to you. 3, we, for our part, are unsure whether the Article 8 argument raised in the HMG skeleton argument is intended by HMG to add anything to the privacy argument developed in the application. If it is, we say with respect that Ms. Fee was unable to explain on what basis you could conclude that the Article 8 rights of a junior civil servant might be engaged in respect to the identity of their employer or the nature of their work, certainly on a class basis, which is the basis of the argument. And it is surprising, if Article 2 is genuinely engaged in the way that appeared to be suggested, that that argument was not deployed in front of or considered by Mr. Justice Swift in IAB.
Do you mean Article 8?
Article 8, I do, sorry. So furthermore, there was, it seemed to us, on your questioning of Ms. Fee, an overlap between what was being said related to Article 8 and what was being said related to Article 2 in the analysis of HMG. And we consider, and we predict that you will consider, that it is important in the highest degree that the issues of privacy and risk should be considered separately and not lumped together as if they are the same. Ultimately, we submit that the reference to Article 8 added nothing to the argument of HMG on privacy, which we consider is an argument you should reject. Little needs to be said about risk this morning. The position is, if an issue engaging the Article 2 rights of a particular junior official is raised and is properly evidenced, then of course those rights will be respected by this inquiry. But that is simply not what is happening here in this argument. Instead, what is happening is that you are being asked, sir, to rule on a class basis without, in any event, the risk alleged being evidenced in any meaningful way. And so we do not consider it would be appropriate or even lawful for you to rule that the names of junior officials should be redacted from documents before they are disclosed to CPs on a class-based risk basis. In the circumstances, we submit that there is no good reason advanced on the basis of which you should accede to the application of HMG, and good reasons why you should reject it. Before we turn much more briefly to the PSNI issue, we must emphasise that if in relation to any particular junior official an Article 2 risk does arise, that will be respected. But HMG must tell us where that is so, if it is so. HMG first raised this issue in March, and this inquiry has been running for a considerable period now. HMG simply must know, and they must tell us immediately, by which we mean early next week at the latest, if there is any such case. So is there any particular junior official in respect of whom there is a genuine Article 2 risk? HMG simply must know, and they must tell us, and identify in which document any such person is named so that the issue can be addressed.
That just reminds me of an issue, Mr. Greenie. We have been talking about junior civil servants in a sense as if that phrase covered the entire spectrum of the civil service. But the application from the Government Legal Department, which was submitted to the inquiry, whilst headed up redaction of civil service names, begins by explaining that the inquiry wrote to GLD in relation to the material provider review of NIO documents. And in paragraph 4, under the heading of application, the document states, "We are writing to formally request permission to redact the names of junior civil servants that have been identified in relevant disclosure provided by the NIO." And the same phraseology appears in Ms. Fee's skeleton argument.
It does.
So this is something, it would seem, which is focused on civil servants who work within the Northern Ireland office. And in the way that you've just been alluding to, that department will have a significant experience and familiarity with the process of risk assessment.
Absolutely, sir, yes.
And we saw that mentioned, for example, in the cases to which my attention was drawn yesterday of RC and others.
Yes. So as we've understood the application, it is focused upon junior officials within the Northern Ireland office. It seemed to us that the first argument that is deployed, namely relevance, is one which on the approach of HMG would apply to all junior civil servants, notwithstanding which department they were in. Equally, privacy would apply to all junior civil servants, whichever department they were in, and it's only in relation to the issue of risk that any specific argument is deployed in relation to the Northern Ireland office. And as you have said, sir, that is a part of government that has particular expertise in the assessment of risk, which only serves to make starker the fact that this argument, that third argument, is addressed on a class basis as opposed to on a specific basis. Mr. Dillapore is reminding me that, is this the skeleton argument? That in Ms. Fee's skeleton argument at paragraph 34, she did say, Ms. Fee's, I should have said counsel to HMG's skeleton argument, She said, and I quote, "As identified in the Secretary of State's application, there may be some junior civil servants, for example, working in defence or security roles, for whom the risks to their safety may be of a different character." So it may be, having regard to that the application is a little broader than just Northern Ireland Office officials, but the response is identical. If there is a person working in the Ministry of Defence or in some other department in respect of whom there is a specific, real and significant Article 2 issue, then please tell us, because it will be redacted, and at the moment you have not, if there is any such person. In fact, sir, reading that paragraph 34 again, I am unsure whether that is a description of people working in particular roles within the Northern Ireland Office or people working in different, wholly different parts of government. I suspect, in fact, it's the former.
Well, that's the sort of impression I had formed, because I was reminding myself of the statement lodged in support of the application as provided by Ms. Carter. And she's the Deputy Director of the Legacy Group in the Northern Ireland Office. And she deals with this concept of defence personnel at paragraph 19 onwards.
Well, Mr. Souter has just drawn our attention to that, sir.
Yeah. And she begins by saying she's considered a position of colleagues working in defence, and she talks about the difficulties that might arise there.
Yes.
Now, she talks about defence staff, and she mentions that there have been circumstances in which members of the military have been targeted. But for my part, I had read that as being defence staff that worked within the Northern Ireland Office. But it's possible I've not given that a broad enough interpretation.
So Ms. Fee isn't here today, no doubt for good reason. And in any event, there is no reason why that point should not be clarified. If your understanding is not correct in correspondence, we would suggest before the end of the day. As we've understood the position of HMG overall, it is that the approach of redacting the names of junior officials from documents it is one that inquiries ought to respect, whether the junior official is working in the Northern Ireland Office or elsewhere. Otherwise, there will be no reason for their reliance, for example, on the protocol of the UK COVID-19 inquiry, but that there is a particular reason for the inquiry to adopt such approach in the circumstances of the Omagh Bombing Inquiry because of the risk profile to those working in the Northern Ireland Office. So that is a rather long way of saying that the approach that we invite you to adopt to the application made by HMG is that it is focused upon junior officials within the Northern Ireland Office, and that if that understanding is erroneous, HMG should inform Mr. Souter of the error and what the true position is before the end of today.
And in any event, if risk is the issue which goes to justify redaction, then it requires to be identified whether it's risk to a civil servant within the Northern Ireland Office or any other department.
Absolutely. It needs to be identified on a case-by-case, by which we mean person-by-person basis, not on a class basis. That is the clear effect of the law. upon which all were agreed yesterday, and in their submissions with the possible exception of HMG. So would it be convenient for me to turn to deal briefly with the PSNI issue?
Yes, please. Thank you.
Little, in fact, needs to be said about the PSNI issue. The position as a matter of law and of procedure appears to be clear. The starting point is that a person investigated on suspicion of a criminal offence but not charged has a reasonable expectation of privacy, with the emphasis on the words starting point, because that expectation may prove in any particular case to be unreasonable, or an interference with a reasonable expectation may be lawful. All in the process appear to agree, or at least not demur from, our proposition that the four categories we have identified provide a logical analysis of where a particular suspect is likely to fit, and of the likely but not inevitable conclusion if they do. And we say not inevitable because each suspect must be given individual consideration and will be the subject of a separate and reasoned decision. So having said all of that, which appears in light of the arguments to be uncontroversial, we do not consider that you need to make a ruling on this issue. Indeed, there is no application before you, and we're unclear on what issue you would be ruling, beyond perhaps expressing a view about some general principles which are in any event agreed, and that may therefore not have much value. And moreover, you have not been invited to make a ruling by anyone. That, sir, we think is all that needs to be said about the PSNI issue, and indeed about the two issues that arise for consideration. And all we finally wanted to say, subject to anything you wish to ask us, sir, is that we are grateful to all call participants for their written and oral submissions and for enabling this hearing to run, we believe, smoothly.
I wonder what you suggest I should do about the submissions I've heard from PSNI and from the other core participants in response to them. As you rightly say, there is no application, and in Mr. Henry's helpful contribution, he sketched out the sort of general principles that he said might underpin the thinking that went into that process. But quite what process, I'm not sure, because I'm not asked to do anything.
No.
Should I simply give some guidance as to the way in which I would approach an application, or something of that sort? That's not. It would not be wrong of you to do so, and it may be helpful, but that is not necessary. Ultimately, it may be that the inquiry legal team could prepare a document that sets out the approach that it proposes is appropriate, although it would not say a great deal more than is said in its skeleton arguments. And if you wish to do so, sir, you could endorse that as the appropriate approach. But it would not seem it would not seem to us to be a useful use of your time, sir, given that there is much for you to do, to spend a great deal of time preparing what may be an interesting academic piece of work on the approach that should be adopted to the suspect's issue. As Mr. Tepper is saying, I mean, what needs to happen now is that individual decisions are made in relation to individual suspects named in individual documents. Yes.
If PSNI believes in relation to any particular decision that we have made a mistake, then that can be raised and ruled upon. And probably the better way for these issues to be raised and ventilated and determined is in the context of a real-life situation.
Yes, because the process that the inquiry will engage in is one in which it receives information from the material provider, and in relation to suspects that will come from PSNI.
Yes.
The inquiry will perform an assessment of its own, taking account of the sort of principles that were canvassed yesterday, and make a decision. And if that decision is either to redact or not to redact, that decision will be fed back to the material provider.
It will.
And at that stage, they'll have an opportunity to contribute and to invite the inquiry to take a different decision.
Yes, and if a dispute arises between the material provider and the inquiry legal team, that will be litigated the wrong way of putting it, that will be argued and determined in the ordinary way at a hearing such as this.
Yes. All right, thank you very much, Mr. Green.
Yes, so we will all next meet in Omagh on the 23rd of June in order that we can hear the opening statements of court participants.